All right, welcome everyone. Thank you for being here with us on, what is it, a Tuesday? I say the day every time we do a training to remind myself what day it is because time seems to be flying as we're already almost out of July. I know time is limited, and I'm glad that you all are here with us today to join us for another installment of our Fair Housing training series. Just to remind folks, this training it started in June and it will go until I believe the last session is in September. I'll put a little plug out about it at the end of this, but it's once a month on a Tuesday every month until September. So for those of you who have already joined us for a session and are back for another one, thank you so much for being here. For those who this is your first session, thank you also for being here. If you need a copy of the previous recordings or anything like that to get up to speed, feel free to reach out to me and I'm happy to get that information over to you. So first off, with some general announcements as folks trickle on in to the training today. As always, this is being recorded. A copy of this recording will be given to all registrants, and it will be posted as well on our FLS training YouTube page. Live captioning has been enabled, so folks should be able to see at the bottom of their screen the black box with everything that I'm saying. If not, there should be an option for you to show subtitles down at that bar at the bottom with all of your Zoom options. This was CLE approved. I will provide that CLE number code in the chat and out loud at the end of the training today. I also will include that code in the follow-up email with the recording and any materials from our presenters. That email goes out 24 hours after the training, and that email comes from Zoom. So just keep your eyes out. And of course, if you don't see it in your inbox, you just reach out to me and I'll get it right to you. So I think the last housekeeping announcement is questions and answers. Please feel free to drop your questions into the chat or the Q&A. We'll monitor both of them. I know in our training in June, our panelists were able to kind of pick up on some of the questions that were in the chat and ask them during the time of, while it was relevant to the subject matter. So that's possible. It could happen again today. So drop them in. We'll do our best to answer them as they come forward. And worst case scenario, we'll have question and answers at the end where we'll run through those lists of questions that you have and read them out loud and get our panelists to answer them. I'm also going to check and make sure that the chat is enabled. For some reason, in my last training, I had a problem with the chat not being enabled. So if that is a problem, please just drop it in the Q&A so I know what's going on. I don't know why that happened last time. So no more announcements. I'll move forward and go forward with introductions. So welcome to Fair Housing Rights. Today we have two presenters, folks that work with me at FLS. So I'm very happy to be showcasing two of our brightest that work in this very important subject and vulnerable population. First up, we have Joseph Cordova. He's an attorney with the an attorney and project manager for our Fair Housing Rights Project. Joe spent the first 2 years of his legal career as an Equal Justice Works Fellow, practicing community lawyering for immigrant families. He has since transitioned such efforts into housing discrimination enforcement and outreach, where he manages Florida Legal Services Fair Housing Initiative Project via the HUD-funded programs. He has a bachelor's degree from DePaul University and an MA from the University of Colorado in public policy and a JD from the University of Florida, Levin College of Law. He has over a decade of experience working with vulnerable populations, performing community development services. In 2018, Joe was recognized by the Levin College of Law with the 2018 Helen Gibble Bleachman Memorial Community Service Award. And along with Joe, we have Christina Benitez, who is the Fair Housing Outreach Coordinator at Florida Legal Services. Christina is a graduate of Ohio State University. Over the past decade, she has worked in a wide variety of professional capacities in both the private and public sector. Christina has experience serving vulnerable populations through her extensive volunteer work in her community. Her work focuses on providing support for the Fair Housing Project by conducting fair housing outreach and education in the North Central Florida. So without further ado, I'm going to turn off my camera and turn it over to our speakers. Thank you so much for being here to teach us today.
So before we jump in real quick, and I'm going to pass this on to Christina to kick us off, I just want to remind everyone and welcome everyone. For those of you who did get a chance to join us last time, there might be a couple of slides that might feel a little repetitive, but we promise that this presentation will be different, so hang with us. But we want to make sure that because today we're going through the basics of Fair Housing Acts, we do have to make sure we lay a solid foundation of the Fair Housing Act. So please bear with us, and without further ado, Christina, I'll pass this on to you.
Thank you, Joe. Okay. I hope everyone can hear me well. And if not, just let me know in the chat, please. Okay, so we're going to start from the very beginning with the basics of the Fair Housing Act. And today we're going to be discussing what it means, what it says, and who must comply with the law. We'll be, again, going over the protected classes, and as well as we're going to show you how to take action. So let's go ahead and begin with discussing what we mean when we use the term fair housing. Okay, so fair housing means that everyone every person has the right to be free from discrimination in all types of housing transactions. So regardless of who you are and other characteristics that may identify you, we all have the same protections under the Fair Housing Act. So you should expect to be treated equally. And that's what fair housing is all about. It's about equal housing opportunity and equal access to housing. And this means that if you have two people with the same qualifications, then they should have the same equal opportunity to secure housing.
And I'm just going to add to that yes. Real quick. Christina, earlier in the week, actually, she brought to my attention, if people haven't seen this yet, please go check it out. There's this website called Unvarnished. It's an online museum and exhibit that goes through the history of housing segregation. And everything Christina just said is one of the focuses of that exhibit, which is the idea that there's fair housing. And then there's the Fair Housing Act. The Fair Housing Act is supposed to respond to the concept of fair housing. So what we're kicking things off with right now is the idea that fair housing is the goal. Fair Housing Act is one of the tools that we're using to get there.
And Joe, I'm going to go ahead and share the website with everyone in the chat. So there we go. That's the website.
Oh, terrific. You had it ready to go.
Okay.
All right. So moving on, yes?
Go.
Okay. So I'm going to talk about the Fair Housing Act, and I'm going to use this sentence here. We're going to break it down here in a minute. So the Federal Fair Housing Act prohibits discrimination in housing-related transactions because of race, color, religion, national origin, sex, disability, or familial status. You'll notice that we have the word federal bolded and underlined. It's important to pause on this word, okay? Because when we talk about the Fair Housing Act, we're today talking about the Federal Fair Housing Act, meaning no matter where you're standing in the United States of America, this law provides protections for you. Now, within all 50 states of the United States, there are individual state fair housing acts. Some of these individual state fair housing acts provide more protections. Some of them provide the same amount of protections. In fact, here in the state of Florida, the Florida Fair Housing Act is pretty much verbatim the same thing as the Federal Fair Housing Act. Okay, the state of Florida did not really add anything to it. But remember, the rule of government is that whatever the federal government gives in regards to protections and rights, states cannot take those away. They can always add more protections and rights, but they can't take away what the federal government has already given. And as we shrink even more into certain counties and municipalities, there are going to be local jurisdictions that have their own fair housing acts as well. And that's really where you do start to see these protections grow. So for example, the state of Florida recognizes the same 7 protections that the Federal Fair Housing Act does. But different counties throughout the state of Florida offer more. So for example, Alachua County, where Gainesville is, they offer 13 protections. So in addition to the 7 that you see on your screen right now, Alachua County also offers marital status, source of income status, citizenship status, and then they specifically enumerate gender identity and sexual orientation as protected status. So depending on where you are in the state of Florida, you may have more than these 7 protections. It's impossible to memorize all of the counties, and it's absolutely impossible to memorize every municipality and what they offer in the way of fair housing protections. But for purposes of today's presentation, we're talking about the Federal Fair Housing Act and these 7 protections. So let's talk about what is a protected class. So one thing that I want to kick things off with, regardless of who you are, your details, your background, all of us, everyone listening today, everyone who's not listening today, we are all members of all the protected classes. Protected class does not specifically mean if you are vulnerable population or if you are a quote unquote minority. No, that's not what the protected class means. It basically means whatever you are, if it's being used against you to deny you housing, it's protected. So when we talk about race, we're talking about heritage, your bloodline, how you identify. That's a little bit different from color because color is specific to the color of your skin and the features of your skin and just kind of how you present. The federal government decided to make sure that race and color were 2 separate things because while a lot of times they overlap, and in fact, if you're going to file a complaint on purposes of race, there's probably like a 90% chance you're including color and vice versa, but they are different. So race is more about your identity and color is literally just the color of your skin. When we talk about sex, we're talking about gender. We're also talking about as of February 2021, so almost a year and a half now, the federal government now enforces sexual orientation and gender identity under the protections of sex as a protected class. The Federal Fair Housing Act did not change. They did not rewrite the law. They simply put, after the Bostock case that came out in summer of 2020, and then there were the executive memo 13988, and then there was a warded memo that sprinkled through HUD. Through those court cases and those memos, sexual orientation and gender identity are now enforced under the Federal Fair Housing Act under sex. This also includes domestic violence and sexual harassment. There are 2 types of sexual harassment that are covered under the Federal Fair Housing Act. Quid pro quo, which is basically, sure, I'll let you be late on your rent as long as you go out with me on Friday night. And more of a this for that type of exchange for rent, exchange for housing with sexual favors, or hostile environment. A landlord, property manager, or any agent thereof of the property management team that creates a hostile environment for sexual purposes is covered under the Federal Fair Housing Act under sex and sexual harassment. When we talk about national origin as a protected class, this gets a little tricky as well. Because under the Federal Fair Housing Act, national origin is protected, but immigration status is not. Now, a lot of times those will overlap, but I'll give you an example. If national origin is protected, that protects you, where you're from, where your family's from, your ancestry. Basically, you could kind of say similar to race, but different. It's more about, the generational heritage, the generational origin of your family, okay? But let's say you're living in a community where there are 9 apartment units, okay? All 9 are currently housed by Mexican families. 2 of those families are without status. 7 of them are permanent residents or citizens, and 2 of them are without status. And the landlord says, you 2, I'm going to treat you differently, or I'm giving you different terms and conditions, or I'm just simply evicting you because of your immigration status. It's going to be hard for them to make a claim under national origin status because they're not being treated differently because they're from Mexico. They're being treated differently because of their immigration status. Because remember, in this little scenario here, all 9 of the housing units are being occupied by families from Mexico. So that it's not their national origin that is creating the differential treatment, it's their immigration status. Now, in a real life scenario, it wouldn't be that clean to use as an example or as a hypothetical in this presentation. The truth is, when families and phone calls come our way in regards to immigration status and making threatening remarks and stuff like that about immigration status, more often than not, those families are also the only Mexican families, you know, in that apartment community, or we're able to kind of make the distinction between how they're being treated differently from how other residents are being treated differently, and their national origin is going to play a role. We can make that connection. But I just wanted to make sure that you all know at the federal level, national origin and immigration status are different, although it is often somewhat easy to find the connection. And remember, in different states and different counties, immigration status might actually be protected. It depends on your jurisdiction. In regards to disability, we have physical and mental, emotional, really everything is covered under disability. What matters is, do you have a disability that affects a major life activity? So eating, breathing, sleeping, working, driving, you know, some sort of major life activity. If you have a disability that prevents you from, you know, equally enjoying your housing because this major life activity that you are not necessarily incapable of doing, but you're limited in performing, that's going to be protected. We're not going to get into too much of the details on this particular presentation, but I believe we are next month. But when we talk about disabilities, we're really talking about reasonable accommodation and reasonable modifications. So in housing, if you have a disability and you seek an accommodation or a modification from your landlord or your property management team to make your living equally enjoyed to that of other tenants, it needs to be approved. A common example would be like a ramp to the first floor over the stairs or something like that. It's reasonable if that ramp is only going up 2 or 3 steps. It's unreasonable if you're asking them to include a ramp that goes all the way to the 7th floor. We're talking about reasonable accommodations, reasonable modifications. Modifications are references to the structure of the building, so maybe grab bars in the bathrooms. Accommodations is that you're allowing room within a policy or a practice to give you the space for equal enjoyment. The most common, and again, we're not going into the details of this today, but we will on a later training, is emotional support animals. So a lot of times we get phone calls from people saying that they're being evicted or they're being denied housing because they're violating a pet policy. But if you have an emotional support animal and you properly make the request, it's not a pet. You're seeking an accommodation to say, I'm going to live with this animal because it's not a pet to me. It's my emotional support animal. It's prescribed from a doctor that I have it. That's what we're talking about when we say you're protected under the Federal Fair Housing Act with a disability. These accommodation modifications need to be approved if they are in fact reasonable. In regards to religion, I went back. There we go. In regards to religion, everything is protected religion. Again, it doesn't matter what religion you are, what religion you aren't. It doesn't matter if you practice a religion or you don't. Faith, spirituality, it's all protected. A landlord cannot say, because I'm of a particular religion, I expect my tenants to behave similarly to my religion or the religion that I've prescribed for myself. Everything is protected. Atheism, agnostic, it's all protected. And then this last one, families with children, has a few details as well. This one is specific to, you cannot discriminate against families with children under the age of 18. This includes pregnant women, and this includes families that are securing custody through adoption. What we're looking at here is that, does the household have minors under the age of 18? If a grandma is taking care of her grandkids and they are going to be living with grandma, and she has custody of these children, or at least some sort of recognized guardianship of them for the time being, and they're going to be considered members of the household, you can't discriminate against that family because there's children under 18. You also cannot say something like, oh yeah, we absolutely love having families here. All of our families live in building C. That's segregating families from the rest of them, okay? So when we talk about protected classes and following the Fair Housing Act, it's not about simply saying, I won't rent to you because of your race, because of your disability, because of your sex. It's that I won't also provide or ask certain things of you or treat you differently, even after I say, sure, you can live here as long as. You can't add an as long as that depends on one of these protected classes. So it's kind of a brief run through of these 7 protected classes, but I hope we have a better understanding of what they are, what they stand for. And if people have questions about them, feel free to jump in the chat box, whatever you can do. I'm happy to answer more questions about that. So where that takes us in regards to how the protected classes are protected, we're looking at certain violations under the Fair Housing Act. We're going to look at Section 804 for the most part this morning with a little bit of 818. So Section 804 of the Fair Housing Act, it identifies that anyone who's offering housing cannot refuse to sell or rent, negotiate, deny, or make available or make unavailable housing due to a protected class status. So I can't refuse to sell a home to you or rent a home to you or anything like that because of your race, color, sex, and then the 7 protected classes. 804B talks about discriminating in terms and conditions of the housing. So similar to what I just said, I can't say, sure, you can rent here, but as long as you don't wear particular religious symbols in common areas. I can't make a different term and condition for you that I do others. One of the most common 804B violations is going to be families with children. You see this a lot in housing communities where they say children are not allowed in the common areas. Well, that means that that family is not able to equally enjoy the entire apartment community as everybody else does. What gets tricky here is that sometimes property management teams will say, well, no, we can't have children in the pool without supervision. That's a safety issue. That's true. That's a safety issue. That's different. You have a business purpose to say no children in the pool without supervision because there is a safety concern, and it's backed by data, it's backed by history, it's backed by experiences. If we have too many 4-year-olds at the pool without their parents, dangerous things are going to happen. But you can't just make a blanket rule because you don't want kids around. That's discriminating. That's saying because you have children, we're giving you different terms and conditions, okay? Now, 804C it's necessary to talk a little more about this one. This talks about discriminatory statements and advertising. So if you're posting something on Craigslist, apartments.com, wherever it is that you post homes for rent, homes for sale, you can't advertise something that says, 2-bedroom home, close to a school, great schools, and just down the street from a Catholic church. No, you just said close to schools. Well, that's violating the families with children because that's basically trying to say we prefer families over non-families. Close to a Catholic church, you're promoting one religion over the other. You can't put anything in your advertisement that prefers a protected class or limits a protected class from thinking that they want to live there. So your advertisements cannot steer people towards you or away from you based on protected class. As far as legal maneuvering around 804C, and this is where a lot of, I guess, case law is going to offer some different, I guess, different examples, is that it's not just discriminatory advertising, it includes discriminatory statements. So if you have a landlord that just tells you verbally, I don't like renting to people like you, that's a discriminatory statement, as long as you can qualify like you to one of those protected classes. And we hear this all the time. We hear landlords will specifically tell a tenant saying, I usually don't take risks with immigrant families, but you seem pretty nice, so I'm gonna go ahead and rent to you. That's a discriminatory statement, okay? This gets tricky because is the discriminatory statement a public statement? Who heard it? Who was in the room when it was said? Was it spoken to you? Was it sent to you over a text? For the most part, all of those should be covered. But again, case law might identify, depending on the jurisdiction, the court, depending on where you're at, they might argue that some statements don't qualify as statements and some do. This is going to be a little bit more gray. But in regards to providing a presentation to a virtual room full of attorneys and advocacy organization staff, we want statements to be as general as possible. We want the idea to be that anytime a landlord or property management says anything out loud or communicates it, conveys this information to you, written or spoken, we want this to be a red flag. We want to say, let's go ahead and go down that rabbit hole, even if we can't turn up any specific case law that's very analogous to what we're going through. We want statements to mean statements. We want it to be very clear and very general. 804D is somewhat similar to 804A, but this one is specifically about misrepresenting the availability of housing. If someone comes to rent and the landlord looks at you, looks behind you, and they see a car with kids in it, they can't suddenly say, sorry, we actually already rented it. Okay, they can't misrepresent the availability of housing based on your protected class. This happens all the time. Let's say you are walking through a tour of an apartment building and you love it. You get a phone call, it's your mom. Your mom only speaks Mandarin. And so you speak Mandarin to your mom on the phone call, and suddenly you hang up and the landlord looks at you and says, you know what, this unit's no longer available. That's national origin-based discrimination. You might not even have any direct link to China other than your mom speaks Mandarin. And she hasn't been to China for, since she was a little girl 50 years ago. It doesn't matter what the connection is. They overheard you speaking another language and suddenly said the place is no longer for rent. That's misrepresentation of available housing. Now, 804F is basically a repeat of A, B, C, and D. And I didn't include E. I just kind of included the highlights here. But 804F is somewhat of a repeat of those, but it's specific to people with disabilities and goes a little bit more into detail with reasonable accommodations and modifications. So 804F was added to the act a little bit later on in history to include people with disabilities. The legal term is in the law is still handicap, but there actually is a movement to get rid of the word handicap in the Fair Housing Act and many federal laws. I haven't checked lately to see where they're at with getting rid of that term and replacing it with disability or differently abled is often another term that's more preferable. But 804F specifically talks about this population. And then section 818, this is kind of the larger violation that you can't find exemptions for. This is just your interference, coercion, intimidation, general harassment, and this would include retaliation or threats. So any property manager or landlord or anybody who's in a position to deny you housing, they can't interfere, coerce, intimidate your right to enjoy your housing. So I'll give you a quick example. Sometimes we'll have a landlord who is behaving poorly towards a tenant, and we're pretty certain it's based on national origin, or maybe it's really close to immigration status. But again, remember, immigration status is not covered by the federal law. But when we get more into the details of their story, the tenant will come forward and say, well, one of the things my landlord always says is that if I don't keep the place as clean as possible, he's going to call immigration on me. That's a threat. Okay, you're threatening someone, you're intimidating someone, you're putting fear inside of them to follow your housing-based rules. So even though immigration status might not be protected, you broke section 818 because you threatened somebody. Okay, so 818 is not really a catch-all, but sometimes you can lean on 818 if you can't really make the connection between words spoken or differential treatment or discrimination. You can kind of land in that area of coercion, intimidation, threatening, retaliation, and stuff like that. So these are the highlights, the sections of the Fair Housing Act that are very important to understand when we talk about what constitutes a violation of the Fair Housing Act. And then real quick, I'll talk about what is included in a housing transaction, going back to that statement where the Federal Fair Housing Act protects anyone in a housing transaction. We're talking about renting a home. And remember, it's not just applying and being approved. It includes the entire relationship of the landlord and the tenant. So different terms and conditions, or you repaired everyone else's air conditioning unit, but you didn't repair mine. And it turns out I'm the only female-led household in the apartment community. Everyone else is male-led, and you seem to get along just fine with all the men, but because of me, as a female, you did not replace my air conditioning unit. That still constitutes a violation of the Fair Housing Act, even though you're 3 years into living there. Sales of a home, you cannot be selective on who you're going to sell your home to. You see this a lot with neighbors kind of talking to the seller saying, hey, we've loved living next to you for 20 years, but can we influence you not to sell to that family? You can't do that if it's based on a protected class. This includes home mortgages and lending. Banks often violate Fair Housing Act. One of the things that we're learning more and more these days is that in addition to just direct denial of home loans and mortgages based on protected class, lending algorithms are becoming more and more discriminatory. So a lot of times the underwriter at a bank is going to try to argue, my hands are clean, it's just the algorithm that turned you down. Yeah, but the algorithm was discriminatory. We had an opportunity last week to spend time at the National Fair Housing Association 2022 conference. And one of the great lines that they said there was, if you can't explain why you've denied a home loan, it's probably because you were discriminating against them. If you can't say why, that's not a good enough reason. You have to be able to explain why you turned them down. You can't blame it on an algorithm. One of the bullet points here, appraisals, and Christina and I were talking about this yesterday, 10, 15, 20 years ago, that word appraisals might not have even made this slide. But nowadays, we're hearing lots and lots of discrimination in appraisals. The story being that a family, let's say a family of color is looking to sell their home. They go to get an appraisal and it comes back a lower price than they anticipated. They get a second appraisal, same thing. Maybe they get a third appraisal, but this time they do what's referred to as whitewashing their home, or sometimes I've heard the term erase their race, where they take down all the pictures of their family in their house. They get rid of everything in their home that reflects that a family of color lives there. And they have a friend who's white answer the door, and now suddenly their home appraises for double the value. So rather than appraising the home, they're appraising the family that lives in it. This is discrimination, and it's really starting to become prevalent. Well, I'm guessing it's always been prevalent, but they're really starting to uncover these stories. Over the last few years, these stories are really hitting the news. And then homeowners insurance is also covered. You cannot base premiums on any sort of protected class. So I'm going to pass this on to Christina now. Here you go.
Okay. So who must comply with the Fair Housing Act? Going back to what Joe was saying with housing transactions, we have to think very broadly and ask ourselves, is the person or the entity involved in this housing transaction, do they have an effect in a person's housing choice? If the answer is yes, then they must comply. And this is not an all-inclusive list, but it gives you an idea that any person or entity involved in the rental or the sale or even the advertisement of a dwelling is responsible. Any person or entity involved in other real estate transactions, such as the lending process and insurance companies, are covered under the Fair Housing Act. And then some of the other entities that we don't typically think of but are also covered under the Fair Housing Act are any entities or people involved in zoning and municipal services, as well as entities or people involved in the design and the construction of new dwellings. So again, I think the best way to answer this question is to always think, is this entity or person going to have an effect on a person's housing choice? Oh, and then I would like to throw in a little question here. So let's look at the last bullet point. What about tenants? If tenants or neighbors are harassing each other, are they covered under the Fair Housing Act? And let's go ahead to the next slide so I can give you an example of what we mean by that. So who is responsible? We have an example here. A Muslim tenant complains to the property manager that another tenant is harassing her because she wears a hijab. Who is responsible? Are the tenants responsible? And you can go ahead and type your answers in the chat box if you would like.
We'll give you a hint as you're thinking of your answer. If you were to file a complaint against somebody in this situation for violating your protections under the Fair Housing Act, who are you filing the complaint against?
Looks like we've got a shy audience today. All right, there's one.
Okay, so we have one. Tenants are not responsible. The neighbor doing the harassing is responsible. Very good thinking. Property management company is responsible. Okay. Thank you very much for your responses. I think both are great. And I would think that, you know, the neighbor, whoever's doing the harassing, would be responsible. But the party responsible in this case would be the property manager if he or she fails to take action. And maybe Joe, you might want to add more to that.
Yeah. The idea is that the tenant technically, or your fellow neighbor, your fellow tenant, technically they're not in a position to deny you housing. They might be interrupting your housing. They might be violating some other law, just general, you know, state statutes around harassing people. But as far as the Fair Housing Act is concerned, they're not the ones denying you of housing. But the property management team needs to step in and mitigate the situation. Just like Christina said, if they don't take action, they're the ones that are on the receiving end of that complaint. Okay, you're complaining that the property management team has a duty to protect your rights under the Fair Housing Act, and they didn't do it. What counts as action? Again, that's going to depend on the situation, depend on the jurisdiction. But for the most part, the idea is that you want to show that you did your due diligence to step in and end the harassment. Does that mean you have to evict the person doing the harassing? It might not. Again, every situation is going to be different, okay? But at least showing that you stepped in is at least, you know, a big step towards saying, I mitigated. The neighbor, yes, okay, thank you, Iola Mousley. The neighbor will elect free speech by saying something, but unless they take a step to deprive tenant of a right or interest, no liability. Yeah, when we talk about fair housing and going back to even the 804C that we talked about, the discriminatory statement, the First Amendment is going to jump in fair housing law all the time. A lot of times, property management teams, tenants, neighbors, they're going to try to say, no, this is a First Amendment right. But again, we're talking about, did your speech lead towards someone else losing their rights? Did it violate someone else's protections? So the tenant themselves might be able to say, I can say what I want, I'm fine. The property management team cannot say they're just exercising their First Amendment right. The property management team has to step in and say, if we don't do something about it, the other person on the receiving end of the harassment, they're not equally enjoying their housing. That's on our shoulders as the property management team. So yes, thank you for throwing that in there, because tenant on tenant harassment cases are always going to bleed into the First Amendment now and that. All right, so yeah, okay, so let's move on to the next slide here. We're going to talk about the exceptions, the exemptions to the Fair Housing Act. So remember, we talked about 804A and B and C. We threw D in and we threw F in. Okay. The following exceptions and exemptions, they exempt the following parties from 804A, B, not C, D, and F. Okay. So if it's an owner-occupied building with no more than 4 units, those are exempt. This is often referred to as the Mrs. Murphy exemption, okay? The idea being that Mrs. Murphy is, you know, an older woman, she's a widow, her husband just died, she lives in this big old house by herself, and she decides that she wants to rent out some of the rooms to make a little extra money and have some company. She's an owner-occupied building with no more than 4 units. She can select who she's going to rent to, and she can discriminate in her decision. But remember, 804C, discriminatory statement or advertising, is never exempt. So Mrs. Murphy cannot put an ad on Craigslist that says, I'm an empty nester living on this house all by myself, and I would love a female roommate. Can't do that. She can put an advertisement out that says room for rent in a home, owner-occupied home, and then based on the people that apply and she meets, she can make her decision based on discrimination. She's got to keep it to herself. Say it to yourself, don't say it out loud, Mrs. Murphy, okay? If people find out later that, hey, that Mrs. Murphy, I'm pretty sure she's discriminating about the people she's renting rooms to, she's gonna stay exempt as long as she never makes that statement, okay? You might be able to piece together some of the, connect the dots that Mrs. Murphy is being racist, but if she never made that statement, she never violated 804C, meaning that the rest of those sections of 804, she will be exempt. Similarly, landlords who own no more than 3 single-family homes. This is the single-family home exemption. So if you live in one home, but you bought an investment property 2 towns over and you rent that investment property out, similar to Mrs. Murphy, you are exempt, okay? And as long as you don't own more than 3 of them, you're gonna be fine. But again, that 804C, you can never get around 804C. So discriminatory statement, discriminatory advertisement, you're always on the hook for that. And then all across the country, but definitely prevalent here in Florida, maybe states like Arizona as well, housing for older persons are going to be accepted or exempt from the Fair Housing Act specific to children under the age of 18. That's where they're exempt. It's just not because you're housing for older persons or 55 and older community doesn't mean you get to discriminate against the other protected classes. It simply means that you can say no to families with children under the age of 18. A couple things to note though, is that if you're a 55 and older community or you qualify as housing for older persons, you actually have to be certified by the state. You can't just have a neighborhood where you look down the street and say, hey, you know what, Fred? A lot of us now are living in these empty nest homes and it's kind of quiet here. Let's keep it that way. And the neighbors can't get together and do a secret handshake and say, this is the way it's going to be. You actually have to go through the process of certifying your housing community as housing for older persons. You can't just say, we want our block to stay quiet. That doesn't count. And then we get a lot of questions here about, well, what if your household is, let's say one of the people is 57 and the spouse is 49 and they have a 17-year-old. Okay, well, depending on the bylaws and the 80-20 rule of 80% of the families qualify or are exempted and 20% can be left open. I don't want to get into too many details about the 80-20 rule and everything like that, mostly because it's a case-by-case situation specific to the bylaws of the housing community. So if you have a housing for older persons community that says, as long as one member in the household is over 55, that's their right to say that. They can allow whoever they want, but they do have the right to have a bylaw that says no children under the age of 18. However, just to throw this out there, let's say one of the members of the household is under the age of 18 and has a disability. Why are you saying no to them? Is it because they're under 18 or is it because they have a disability? You really have to make sure that if you're housing for older persons, that the bylaws are specific to why you're saying no to this family, okay? Because if other families get to have people under the age of 18, but this family didn't, then maybe it was disability-based discrimination. Or if you reverse it, everyone in this household with a similar disability is welcome into this community, but the family who's had the individual with the disability under 18 was denied, then that was families with children-based denial, and that is going to be exempt. I think I just kind of spun my own mind around a little bit and got a little confusing, but the idea here is that sometimes the bylaws of the community is going to get confusing because you're going to hear people call and say, I don't understand why they discriminated against me. They let that other family in, but they wouldn't let mine in. Well, we have to get into the details of why, what one was allowed in and why one wasn't. Okay. So what we're getting at here, and that lends perfectly to this next slide, we're talking about discrimination and the nexus of the protected class. This is something that a lot of phone calls we get, I don't know if they're not understanding it, or if maybe they're just so heated in their own emotions that they don't want to understand it, or they're just too emotional about the situation. The covered issue needs to have a perfect, or not perfect, it needs to meet the covered protection. So if you're refusing to rent to a family with children because they have children, that's discrimination. If you refuse to rent to a person from another country because they're from another country, that's discrimination. Let's look at this fourth one here. Refusing to rent to a person with an emotional support animal because the animal violates the pet policy. There you have the nexus, okay? The person with an emotional support animal is making a reasonable accommodation request to have this animal with them. It's not a pet, therefore you can't deny them. But sometimes we get phone calls where there is no nexus. So a family with children, you can still be evicted because you failed to pay rent. You're not being evicted because you have children. You're being evicted because you failed to pay your rent. Just because you are a member of a protected class doesn't make you immune from following the rules of your lease and other landlord-tenant laws. Remember, we're all members of all the protected classes. So we're not immune, we just have to actually have that nexus. We get maybe not this specific example, but we get something similar a lot. Someone will say like a smoker can still be warned for not complying with the non-smoking policy. Smokers is not a protected class. I'll give you an example. I had someone call, and I can imagine that you all will know that this is probably happening all across the country. People are being denied housing for political ideology. It's not a protected class. So I've gotten phone calls where someone says, you know, my landlord evicted me. We had an argument the other night about the election. I said this, they said that. And the next day I had an eviction notice. That might be violating some landlord-tenant laws as far as, you know, giving a proper 7-day notice to cure, you know, what are you actually evicting them for? Did they actually violate the lease? That's probably a violation of landlord-tenant law. And while it is discrimination, because you're discriminating against someone because of their political ideology, it's not a violation of the Fair Housing Act, because political ideology is not a protected class. So a lot of times we do get phone calls from people saying, I feel I'm being discriminated against. And the answer is, it does sound like you are being discriminated against, but not based on one of your protected classes. And then this last one here is that a person with too many pets, they can be denied housing for violating a pet policy. And just to kind of make one more wrinkle to it, let's say you're a tenant that has an emotional support animal request and a doctor's letter, and you get approved, and then you bring in 7 dogs. You can still get evicted for having 7 dogs because your emotional support animal approval was for 1 dog. Okay, so remember, you have to keep in mind, what are you actually being denied housing for? There has to be a nexus between the cause for eviction and your protected class status. I'll pass this back to Christina.
Yeah, so as Joe was saying, when we're doing outreach, we get a lot of stories or complaints from people who are not necessarily, whose covered issue is not necessarily tied to a protected class. And however, it's important that we're aware and we keep in mind that there are other protections. An example that I like to use is people with disabilities. If there's a covered issue that is not necessarily tied to discrimination based on your disability under the Fair Housing Act, it could still be, you know, covered under the ADA or the Americans with Disabilities Act. So I think it's good to keep this in mind, and also, you know, have a list of resources that you can provide and share with people who are not necessarily facing a housing discrimination, but might be facing other housing related issues. And Joe, anything else? Okay, yeah, back to you.
Yeah, and then I want to make sure we have time for this slide before we run out of time. I want to have some time for questions. So let's say you're in a situation where someone has violated the Fair Housing Act against you, one of your clients, someone you know. What can they do about it? So how is it enforced? So the Department of Housing and Urban Development is the agency tasked with enforcing the Fair Housing Act. You can file a complaint directly to them. This can be done online by filing the online HUD Form 903. It's a very simple form. It asks for just some quick details about the individual who is discriminated against. There are 2 questions that limit you to 4,000 characters. And then there are a couple quick questions about the person that is doing the violating. It goes to HUD, okay? This is something that you can do with your clients. You can pass this on to us. This is what we do. We're grant covered, and this is very much what our grant wants us to do more of, is find individuals with these stories so we can walk them through filing these complaints. Once you file the complaint with HUD, more often than not, HUD's gonna review it and they're gonna send it down the line to a local FAP. So you can either file directly to HUD or you can file directly to a FAP, which is a Fair Housing Assistance Program. These are organizations that are funded by HUD to do the work of HUD, but at a more local level. In the state of Florida, we have a statewide FAP. That's the Florida Commission on Human Relations. We also have 6 local FAPs. So Broward County, the city of Orlando, Jacksonville, Palm Beach, Pinellas County, and the city of Tampa. You can file fair housing complaints directly to these organizations and keep it more local. What filing a complaint does is that it triggers an investigation. The investigation goes through, they interview the aggrieved party, they interview the respondent party, and they try to get an idea of what actually happened. And what they're doing there is they're trying to get to a determination of cause or no cause. If HUD finds a determination of cause, it can continue to go up from there towards an administrative law or an administrative court. And an administrative judge can enact, well, at the federal, across the country, the terms are that the administrative judge can offer damages, punitive damages, injunctions and stuff like that. State of Florida, though, an administrative court cannot offer emotional distress dollars and damages. You have to have a jury trial in the state of Florida. So if you have a case that you think we got a no cause determination from HUD, but your client thinks that there might be a benefit to going through a state or federal court to seek emotional distress dollars, you can take that no cause determination, say thank you to HUD, tip your hat, and then go take it over to a state or federal court and file a lawsuit. What's also unique about the Fair Housing Act, different from some certain other laws, for example, equal opportunity, you have to exhaust administrative remedies. The Fair Housing Act, you do not. So you can actually file a HUD complaint at the same time you file a lawsuit, and you can have both going at the same time. However, once you actually enter the courtroom on either side, you have to stop one of them. So if you file a complaint and it goes through the investigation, you get a cause determination and you're about to go to an administrative court, and it happens to occur at the same time you're about to go into a federal court based on the lawsuit you filed, you're going to have to walk away from the administrative court and just settle your business at the federal court. You can always settle early with a conciliation agreement on the administrative side, and obviously any court process or litigation can settle early. The difference between the complaints and lawsuits is that you have 1 year to file a HUD complaint from the last occurrence of discrimination. And as far as filing a lawsuit under the Federal Fair Housing Act, depending on the jurisdiction, more often than not, you have 2 years. But again, you want to pay attention to the jurisdiction, especially if you're filing under your state Federal Fair Housing Act or some other jurisdiction, you have to make sure you pay attention to that. So that brings us to the end of our discussion and presentation. These are the contact information for us, Florida Legal Services. And I guess with the remaining 5-6 minutes, we have time for some questions.
All right, well, thank you so much for that presentation. It was such a great combination of being brought up to speed on the law and then also given the practical knowledge. It's very clear that the both of you have experienced a lot of vetting of cases about these issues. So thank you very much for melding the education with the practical knowledge. I don't see any questions in the chat. I will give folks, a few minutes to see if they want to drop anything on in. And in the meantime, what I'll do is I'll put the CLE number to buy a little time into the chat. And folks, if you have any questions, the chat or the Q&A, I'm monitoring both of them. So feel free to drop them in.
Either we covered everything so well or people fell asleep, either or.
I think it's that you covered everything, but I'm biased.
Okay.
Okay, so the CLE number I have here is lately they've all been this very similar number set. So I'm wondering, I mean, I know it's okay, but I just feel like I mistyped
While
that.
you
Oh,
type, we do have one question. So the question is, has anyone had good success with the conciliation process? If there are others in the chat box that have gone through this process, feel free to jump in with your experience. I know on my side, the conciliation process on the admin side, it comes and goes. So it'll show up 2 or 3 times before the investigation is complete. They do like a round of investigating, and then they reach out to the aggrieved party to say, would you like to settle? And basically the aggrieved party gets to make an offer to the respondent party saying, I'll drop my, the investigation, the complaint, as long as you do the following. And that's when you can ask for the sun and the moon. You have every reason to ask for anything you want because you're basically just negotiating. As far as cases that end in conciliation versus going further than that, again, it's case by case. I don't know. I like the question, has anyone had good success with the conciliation process? I guess success is subjective. If the client walks away satisfied, I guess that's a success. But from the side of ending housing discrimination, I don't know if conciliating and coming to a settlement is the best slap on the wrist that we're aiming for. So I like that question. I think I just have an open answer for it. Comes and goes, you win some, you lose some. Yeah, does anyone else have any responses to that?
and in the meantime, CLE number is 6146. It's in the chat. We have a few more minutes, folks. Anybody want to share their stories, their war stories, their experiences? We can try, let me see, we can try something and I can see if I can unmute people. All right, here's another one.
Yeah, aren't the admin complaints available to everyone as public record? Yeah, that's another consideration, is that as you move further along in the administrative process, little by little, things become more and more part of public record. There's going to be some good parts and bad parts of that. Sometimes becoming part of public record means that the respondent party wants to end as soon as possible because they don't want their names out there as violating the Fair Housing Act. But a lot of times that means that your client is going to step back because they just want to be done. They want to move on with their life. They don't want their name getting out there and stuff like that. And we didn't talk about this today, but if you're running a testing program, you don't want your testers to be exposed. You don't want them to be identified because then they're going to have a harder time doing testing down the road. So if you have a complaint that's moving forward that involves a tester, you basically have to recognize that you might be losing a tester because now they're part of public record and they're exposing themselves.
So when we do have someone with a hand raised, I'm seeing if they need some assistance to speak, and I see another.
Yeah, about the conciliators. I agree. I've thrown numbers out in the conciliation process that I use based on case law and based on advice I've gotten from a lot of these trainings. So for example, sometimes you say, every time you violated my rights under the Fair Housing Act, I'm going to say that's worth $4,000. So when you get to the conciliation process and you say, I want 20 grand, it's because you can point to 5 times that they violated your rights. But you're right, a lot of times the individual on the administrative side doing the conciliation is trying to make sense of it rather than just simply being in the middle of it. So I agree, sometimes it is a bit fruitless and doesn't go anywhere. If you file directly, you can use the admin complaints public record as part of your discovery. Yes, that is correct. So one of the things we've been trained as a fair housing program under HUD is that once we're going to take a story or take a situation and move forward with a complaint, we have to basically make sure that every little note we write on a napkin might become discoverable at some point, including what's become public record. So that's when you really want to start to take an idea of what is the path from here to the finish line. But yes, you are right. Administrative complaints and public record can be used as part of your discovery, which means it's also used as the other side's part of their discovery. So what you put in the complaint, you want to be careful not to expose, show too much of your hand, expose too many names or anything like that.
All right, right at 1 o'clock. Folks, if anyone else has any additional questions, our presenters have graciously offered some of their contact information. So I've opened the door for you to ask them at any time. And I'll put in a plug for the next session of this training series. The next session is going to be Tuesday, August 30th, same time, same place. And that is going to be Fair Housing, Everything You Need to Know About Disability Rights and Emotional Support Animals, but we're afraid to ask. And the webpage is, I'm sorry, there's something just came into the chat. There was a webpage mentioned at the beginning, but it's not in the chat. It was put in the chat a little further up. I'll repaste that. I will also make sure that I include that website for you all in the follow-up materials. How does that sound? Let me see. There we go. Repasted. Now it's in. And Christina did it too. Awesome. But I'll make sure I put it in the materials. So with that, everybody, please enjoy the rest of your afternoon. Any last thoughts, Joe, Christina?
No, thanks for having us, and thanks everyone for
Thank you.
attending.
Yes, thank you.
Thank you for being here. All right, everyone, signing off. Have a good rest of your Tuesday.
Bye.
Bye.